I'm happy to provide you today with a CLE, not from me, but from my partner, Rosa Feeney, and our senior counsel in the coverage unit of Smiley and Smiley, Jocelyn Sider. Both Rosa and Jocelyn are experts in insurance coverage and specifically declaratory judgment actions. They just did a live CLE that I thought was just so fantastic, and the information is just really important. And I figured I would share it with you. So you can get CLE credit for this episode, just like you have for many of the other ones. Just look for the codes and fill out the forms in the description and enjoy this wonderful program from Rosa and Jocelyn on handling declaratory judgment actions.
Thank you, everybody, for joining us. So we had part one, DJ Wars, and what we talked about there was the who, what, when, where, and why of declaratory judgment actions. If you want to see that, you can go onto the Academy website and you can see that CLE. And that was really about like the mechanics of declaratory judgment actions, where today we're going to really talk more about the actual discovery and the processes that go on during the case. So just for those of you who do not know us, where I'm the chair of the Insurance and Coverage Division of Smiley and Smiley, and we handle coverage matters of all kinds for policyholders. We also handle them sometimes for plaintiffs and plaintiffs' firms who are getting disclaimers or reservations of rights and want to have an analysis of, how is it impacting the case? How's your client going to recover? And then we also do some insurance carrier work. So we're really well-rounded in that respect. And everybody on our team has worked on the defense side as well for many, many years. So we really have a lot of background in this, and I hope that you get something out of it. So when we're talking about DJs and discovery, let's go to the paper discovery first. Unlike a regular, let's just say trip and fall or an auto case or even a labor law case, where you kind of have those discovery demands already, in the can, so to speak, DJ actions are not like that. There are certain things you're almost uniformly going to ask for, but there are certain things that you would not be entitled to. It depends upon what the issue is in your case. So the thing you have to first determine is, what is the issue? What am I trying to figure out? What am I trying to prove? And I know that's true for most cases, but with DJ actions, it's so different. Sometimes it's, is it late notice, or sometimes there are a late disclaimer or an ambiguity in the disclaimer, or is it a material misrepresentation? There's so many different issues that come up in these DJ actions. And you really have to tailor your discovery demands to that, because technically you're not going to be entitled to certain things in certain cases. Okay, so we're going to go through and try to give you some examples and go through some of the things that we specifically demand on most of our cases. And again, sometimes we don't demand all of these things. It just depends on what the issue is, right? So we're first going to talk about the discovery that we serve typically. And, most of this right now in the beginning applies to what a policyholder or a plaintiff would serve on the insurance carrier. So you want to go ahead and head that off, Jocelyn?
Sure. So in general, what the policyholder is entitled to is going to depend on the relevance in the coverage action. Primarily, we would demand the complete claim file. It's the most critical piece of discovery. You want the entire file, including claim notes, whether they're electronic, paper form, something else. Typically, the insurance carrier is going to try to withhold portions of these, so you really need to understand the law as to what's discoverable. We look for all claim notes from intake through present. We look for their communications with defense counsel and with coverage counsel if they've retained it. Internal memoranda, communications regarding the claim. These could be internal to supervisors, managers, other adjusters. They could be external, brokers, agents, to the policyholder, to the claimant, if there's a separate claimant. We're going to look for activity logs, diaries, chronological summaries of the claim, any and all documents received on the claim. They could come from the insured, they could come from claimants, again, third parties, and reserve information such as amounts, adjustments, and rationale. Now, again, we ask for these. Again, you're going to tailor them. For example, if it's a material misrepresentation case, you're really going to focus on what information they obtained from the policyholder. They may have taken an examination under oath, or they might have just taken a recorded statement. They may have had the policyholder submit a written statement of loss. So you want to look for all those things, but in those cases, just as an example, the reserves might be less important than they would if there's a separate third-party action going on or a separate injured claimant. So those are the main things we look for in the claim file. But again, you want to make sure that you're tailoring it based on the facts of your case.
And one of the things that I want to point out is that this is usually the most important part of discovery. It is, when you get, and we're going to talk about when you're entitled to see different aspects of the claim file, because you're not entitled to see the entire claim file. And there's circumstances where, for example, if you're a plaintiff and the case is still going, right? The plaintiff should not be able to see reserves or an analysis of liability and damages. So it really depends on what stage the underlying case is in, who the parties to the DJ are. There can always be confidentiality put into place in these different cases. And I'm going to talk about some of that in a little bit to protect some of that, because sometimes, for example, a policyholder needs to see those things, but you don't want the plaintiff's attorney seeing those things, right, from the carrier's perspective. So the other thing I'm going to mention is you should just assume that the claim file is discoverable, and do not put color commentary into your claim notes on the carrier side, and even defense counsel. I've seen reports come in from defense counsel after the depositions, and they always, the defense counsel always has to, they comment on whether or not they thought that the witness was credible or that they'll make a good appearance, right? And that's fine. But I've seen a lot of other things put in as descriptions of, witnesses and parties to a case that are completely inappropriate. And same thing in the claim file, opinions about people. That should not be in there, because it's going to come in. And particularly if you're talking about a bad faith case, that does not look good, obviously, for anybody. So keep it clean, keep it professional, make sure that you have everything in the claim file on the claim side of things, because I will tell you that if I see a gap in the claim file, I'm going to flag it. Well, what's going on here? How come there's nothing here? Where was the documents that were attached to that email? Were there text messages, right? Because now text messages are a big thing, right? They didn't used to be, but now it is a big thing. So you really need to look into all forms of communication. What about, if it's not text messages, if it's WhatsApp? I don't know, you're communicating with an insured through WhatsApp. That's possible. So these are all things that you want to make sure that you're asking for all electronic communications with anybody during the discovery phase of the case. And we're going to talk about, what you're entitled to and up to when you're entitled. So the next important thing is that in a coverage case, there are two different files. So what happens is the claim comes in, the carrier opens the file, and they start to investigate it. Normally, one of the very first things they're going to do is they're going to verify that there's coverage or determine whether or not there's a possible disclaimer or exclusion. It's one of the first things they have to do, right? If they determine that there's a coverage issue, they technically should be opening a second file, and that should be the coverage file. So there should be the claim file and there should be the coverage file. All right. And the coverage file will, be opened as soon as something is flagged, right? This is maybe a coverage issue. And then once it's flagged, then they start to do their investigation. Oftentimes you'll see that they say, okay, we got to hire coverage counsel on this one because, we can't figure this out, or we need an opinion a formal analysis for our file, right? So now coverage counsel gets it, coverage counsel reviews it, coverage counsel writes a legal opinion, and sometimes they'll draft a disclaimer, right? And every company has a different technique for this. So this is something that you have to explore during discovery in a DJ. But sometimes what happens is that the counsel will give an opinion and a draft disclaimer, and they give it to the carrier. And then they see if the carrier agrees, right? The carrier reviews it, and if they agree, they issue the disclaimer. Okay. So, what's discoverable, right? So right now, I'm sure there's people raising their hand saying attorney-client privilege, but that's not necessarily true. So in coverage, if you hand a document to the attorney, right, a police report, that doesn't become privileged because the attorney has the police report. Same thing for summons and complaint. Same thing for potentially investigation in the claim file. It doesn't become privileged just because an attorney has it. What is privileged is when they're giving legal advice. So the case law says that potentially just communications with an attorney, the coverage lawyer, are discoverable, and also communications and what the attorney reviewed could be discoverable. Okay. And so sometimes what happens is, for example, in some cases, I'll demand a copy of the coverage opinion. And when we get the coverage opinion, if I get it, it's redacted, right? So they have all the facts in there. It'll say, this is the background facts of what the attorney considered. And then when it comes to the opinion part, they black it out. That's acceptable. That's where they're giving advice, right? And it's also important to seek that if you can, because that's going to tell you what information that attorney reviewed. So if they didn't have the correct information, or they didn't have all the information when they issued that coverage opinion, that might be a basis to overturn the disclaimer, right? They didn't have sufficient, that's not correct. So these things they're important to look for, and it's normally will be a fight to get it. But not always, because I think they're aware of the law. And the law says that if a document is mixed, it's called like multi-purpose, right? Or mixed purpose, then there are things that will be discoverable. Now, we're going to talk about more of that in a second, but the next thing that Jocelyn's going to talk about a little bit is the underwriting file.
Just want to add to what Rosa was saying too, even if the facts that coverage counsel was looking at aren't correct, it can give you an idea as to what their position is and what facts that they were considering. So it can give you some insight into how the carrier intends to defend their disclaimer just by virtue of seeing, hey, they focused on this and they didn't focus on that. Picking back up where Rosa left me, the underwriting file is something else we ask for. It's particularly important when there's a case involving policy interpretation, ambiguity, or material misrepresentation. So if the carrier is denying based on fraud, for example, specifically fraud with regard to the policy procurement, you definitely want to get a copy of the underwriting file, not just the claim file. And some things we look for are the insurance application or the policy application, as well as any supporting documents that the insured submitted. We look for the underwriting guidelines that are applicable to the risk. If there's an underwriting manual, we want to get a copy of that as well, because they're going to need to defend their position. And if they don't have written guidelines as to what risks they insure and why, well, then how are they going to disclaim or rescind the policy in extreme cases? So you want to also look for what risks the insured inspected to cover when it sold the policy. Were they expecting to insure a 3-family house, or were they expecting to insure a 2-family house? Were they expecting to insure a vehicle that's only being used for personal use, or were they also aware that, the insured was running a moving company or something of that nature? And we also want to look into how the insurer was interpreting the relevant policy terms when the policy was incepted. Because if there's a dispute as to what those policy terms meant between your client, the policyholder, and the insurance carrier, obviously you want to be aware of that. Any and all correspondence between the broker and agent and the underwriter, and any and all policy renewal documents, including whether there were any changes made to the policy at the renewal. So those are just, a handful of things that we really look for.
And I'm going to give you an example. I have a case where, or had a case where it looked like there was one insured, but the other insured was not on it, right? There was an individual and an entity. And the carrier disclaimed as to the entity. But it turns out, once you got the underwriting file and the documents, it turns out this entity was named at some point, and at some point it got dropped, right? So it's important to look, obviously, at all of these underwriting documents. And also, there's case law that talks about that if they're going to prove their case, if a carrier is going to say we would have never issued that policy, then they have to prove through underwriting guidelines that they would never have issued the policy. So, these cases get a little bit more in depth. And if you've ever seen an underwriting file, it's gibberish to most of us.
Can
So
confirm.
it's not, it's not easy to read, but they're important to have. So go ahead, Jocelyn.
Sure. Another thing we want to look for, and often this is included in the claim file, but not always, you want to look for the investigation file. These are typically investigative reports that the claims adjuster may have prepared, or they may have hired a third party to prepare. They're prepared in the regular course of business to aid in the carrier's decision to either provide or deny coverage, and those reports are discoverable. The courts do draw a critical line. Reports prepared before the decision to disclaim are considered discoverable. Reports prepared after a firm decision to disclaim may be protected, and we'll talk more about that a little bit later on. But when I refer to an investigation file, again, that's going to include investigative reports either from internal adjusters or third-party investigators. Scene investigation reports and photographs. You typically see these obviously in the auto accident scenario. You also can see them in homeowners claims as well as labor law claims. They come up a lot, obviously. Again, any and all recorded statements taken of the insured, claimant, witnesses, any and all examination under oath transcripts, and any and all special investigations unit reports. So those are the SIU reports, and that's, for anybody who might not know, that would be typically the carrier's internal team that handles fraud investigations.
And again, this is the kind of thing where you want to get those investigative reports because you want to see when the carrier became aware of certain facts. So if you're watching this, you probably already know, a carrier has, under certain circumstances, right, a duty to disclaim as soon as reasonably possible, right? So if they were aware of some fact because it's in the investigative report, or they were aware of some fact because it was in the underlying complaint, right? Or they were aware of it because their insured told them that fact at some point, and then it kind of doesn't get disclaimed until later, there could be a problem. So from the insured perspective or the plaintiff perspective, that's something you always want to look at. The next thing is claim manuals and best practices. Okay, so most carriers have claim manuals of some sort, right? And these claim manuals could be very specific. They could be very general, right? And it tells the employees, right, this is what you're supposed to be doing in this particular case. You have to, you have to perform to this standard. Here's what we want you to do. So it's important to get that because, in your case, if you are, again, a policyholder or plaintiff, you can prove they didn't comply with their own best practices or their own claims manual. And again, this is one of those documents that you're going to probably have a fight getting. The other thing to be careful with this is if there's a carrier, but there's a third-party administrator that's really handling the claims, there could be two types of best practices, right? There could be a best practices for the TPA with the third-party administrator, or there could be a best practices and a best practices for the carrier. So now you're talking about two different best practices. So, just be careful about that. Then, of course, you want to get the insurance policy. But, one of the things, we say this every single time, read the policy, read the policy, read the policy, the 3 cardinal rules of coverage. But it's absolutely true. That policy should be certified. But if it's not certified, sometimes it takes them a while to get the certified. It should be certified. You have to look at the deck page and look at every endorsement on that deck page and make sure that every endorsement that's on that deck page is in that policy. If there's there's endorsements being touted as being part of the policy, but they're not on the deck page, they're going to have a problem. And I actually had a case like that where it was right around COVID time, and there was, everybody was, the virus exclusions were going around. And so the carrier sent my client a letter saying there's a virus exclusion in your policy. And when we looked at the policy, there was no virus exclusion in the policy. They probably included it later and didn't include it in his policy, but it wasn't listed on the deck. So it's important to do that, even though it's time consuming to go through that. But it's important to go through that. Maybe now with, all the AI, maybe you could just throw it into AI and it'll tell you if it's there or not. All right. So other things that are basically in the claim file. Go ahead, Jocelyn.
Sure. Some of this may already be in the claim file. Some of it might be available in NICEF, but you want to make sure you're obtaining all the discovery from the underlying action. So typically the coverage action begins, anywhere from a month to several years after the underlying action begins. But you want to make sure you're getting anything and everything that was exchanged, because it's going to affect your investigation and your analysis and the decisions you make, such as moving for summary judgment or what have you. Deposition transcripts from the underlying action can be invaluable, especially in cases where there is a dispute over the plaintiff's employment or, again, material misrepresentation cases. You want to get the bills of particulars. Sometimes there's more than one, as we all know. Get copies of the pleadings. Again, this is typically available in NICEF, but you want copies of any and all complaints, amended complaints, answers, cross claims, third-party actions. And you want to make sure that you have any and all copies of contracts between the parties in the underlying action, especially in scenarios where you might be moving or you might be seeking additional insured coverage for your client. And the contracts sometimes are uploaded as exhibits if the underlying action has proceeded to motions for summary judgment. A lot of times they're not. And when you receive, for example, those contracts, you want to cross-reference them with the deposition transcripts. Rosa and I have a handful of cases right now where there's some question as to which contract applies to the parties, and the parties are taking different positions. So you want to make sure that you have all of that available to you. And it's nice if you can get it from the underlying action. If not, you can get it from perhaps defense counsel or your claims adjuster.
Attendance code number 1 is ADJ 319. That's ADJ 319.
Right. And even, sometimes let's just say it's the carrier, they deny coverage, right? So they're not involved in the underlying action at all. Then they're going to be the ones seeking it from the insured, right? Saying, I need copies of the depot transcripts. I need copies of all the discovery. And like I said, you can get a lot on NICEF, which is fantastic, but sometimes you can't get the actual responses to discovery demands. You can't get certain investigation. You can't get those things. The other thing is interrogatories. In a DJ action, you can file or serve, interrogatories. Unlike a personal injury case where if you serve interrogatories, you're going to waive your deposition. That's not the case with declaratory judgment actions. You can, and of course, that's a state court rule. That you would waive it in state court. But in any case, you're allowed to have interrogatories. And interrogatories are really useful and informative. If you have a late notice, let's just say it was an untimely disclaimer, right? And you're going to ask that carrier in your interrogatory, when did you first become aware, and how, and who'd you talk to? And you're going to ask them all these questions. And then they're going to answer you. And then when you go to the deposition, you have that information already to look into it further, right? And so I had a case where this happened. It was exactly an untimely disclaimer case. And then we found out that the way that they were notified was from the plaintiff's lawyer from the underlying action. And in New York, the plaintiff's lawyer under Insurance Law 3420 is permitted to give notice of the suit. So that's what happened. So we were able to know that that was their first notice, right? And that in our position, our argument was it didn't comport with the timing of the disclaimer. It was too big of a gap between the time that they found out about the facts of the case and the time they disclaimed. So Jocelyn's going to talk a little bit about discovery from the insurance company's perspective.
Now we're going to talk a little bit about what kind of discovery you want to demand from the insured if you're representing the carrier. Anything relating to notice, so documents relating to when and how the insured first became aware of the occurrence, who put them on notice? Was there an injury report that day? Did somebody reach out to them a month later and demand their insurance information, what have you? Any and all correspondence with the broker regarding notice to the carrier. This is more common in commercial cases. I think personal lines, the insured will typically report it directly to the company, but sometimes they call their agent. And again, any and all incident reports they may have, any internal memoranda, accident reports. So if somebody emailed the boss and said, hey, Joe got hurt on the job today, you want to get a copy of that because that's going to establish when the insured first knew that something happened. Then you want to look for policy compliance documents. So in labor law cases or construction cases, you're looking for contracts between the insured and any subcontractors. Those are especially important, again, in additional insured disputes. Any certificates of insurance provided or received, evidence of compliance with policy conditions. Did they put their insurance company on notice? Who did they call? When did they call? Or did they send a letter? How did they do that? Did the insurance company ask them for more documentation? And if so, did they cooperate with that request? You're also going to look for application-related documents in material misrepresentation cases. So again, policy application, all documents they submitted in support of their application or relating to the policy procurement. You're looking for communications between the insured and their broker or agent regarding the policy and the application. Did anyone run a prior claims history or a loss run? You want to get copies of those as well. And then you're looking for financial and business records relevant to the insured's operations at the time of loss, employee records, payroll records, especially important in labor law cases, but can also be important if they're submitting a claim for lost business or, for example, I had a case with a gentleman who ran some sort of salvage operation and a tree fell on his boat. And then he submitted a bunch of documents alleging that because the boat was damaged, he wasn't able to fulfill contracts. So you're looking for more broadly proof of loss documentation and financial records supporting their claim.
So now we're going to talk about what is discoverable and what's not discoverable, right? This is where the rubber meets the road. So a document is not privileged just because somebody puts confidential on it, right? There are very specific privileges under the CPLR of what to determine what is privileged and what's not, right? So you're talking about attorney-client privilege, attorney work product, okay? Materials prepared in anticipation of litigation, right? There's proprietary information, right? There's a bunch of different categories, but you need to determine what's discoverable and what's not. And one of the things that you're always going to want is you're going to want a privileged log, right? So if you're going to get a stack of discovery and they're going to redact a bunch of stuff from it. And the way it works, if you're not familiar with this, is they'll produce these documents and then at the bottom they put a Bates stamp. It's numbers or letters. Everybody does different at the bottom of the document. So that's their document 0000, 12, whatever it is. And then everything's going to be, portions of it are going to be redacted. That needs to be accompanied by a privilege log. And that privilege log needs to state the basis for the privilege and what that document is. What is it? Is it a claim note? Is it an investigative report? Is it the coverage opinion? Okay, and so when you're looking at the claim file, Jocelyn's going to talk a little bit about, what's that critical dividing line of when things are privileged and not.
Sure. So the courts are going to look at the date the firm decision was made to deny the claim. That's generally your bright line cutoff as to what is and isn't discoverable. Everything before that date, generally discoverable. Everything after may be protected. So just some examples. Claim notes prepared before the disclaimer, investigators or adjusters reports that were made before the decision to pay or reject the claim, mixed purpose documents, as Rosa discussed earlier, coverage counsel's opinion letters prepared pre-decision, draft disclaimers, draft reservations of rights, again, pre-decision, prior claims information, reserve information, claims manuals, and documents regarding or relating to similar claims. Again, all of that prior to the decision to deny the claim is going to be discoverable. Things that are going to be potentially protected post-decision. Materials prepared exclusively in anticipation of litigation. Again, that has to be after a firm decision to disclaim. Attorney work product, as we all know, that must be generated by an attorney for the purpose of litigation. And also privileged attorney-client communications that are, quote, primarily or predominantly of a legal character. That's from Spectrum Systems International Corp v. Chemical Bank. But again, those are typically going to be protected once the decision to disclaim has been made.
Now, one of the things, to explore on the policyholder plaintiff side is oftentimes the carrier will retain the lawyer to prepare a coverage opinion, and they prepare the coverage opinion, the prepared draft disclaimer, and then it goes to the carrier for approval, and then the carrier approves it. So technically, the decision to deny is not until it's approved by the carrier. So these are things, again, you're not entitled to their legal opinions, but you're entitled to see what it is that they based that opinion on, and particularly if they were acting in an investigatory fashion at all, like making phone calls or talking to the broker or whatever it is, okay? So again, as we said, just because it's labeled confidential doesn't make it confidential. The thing is that they're practical tips, right? So demand the privilege log every time you have one of these so you can see what's being, marked as privileged. And, they have to identify the exact thing it is. So it's this date that was this entry, and then this is the privilege, okay? And you can't always tell what it is. That's the hard part of it. But you have to determine based upon practicalities whether you're going to fight over every single thing or you're going to accept that and move on to something else that might be more important. And that is something you just have to determine.
Use your judgment.
Yeah. So we're going to quickly talk about depositions in DJ actions because we only have about 20 minutes left. And we have a lot of other materials. But if you guys, again, if you have any questions, we have the materials that were submitted with this have our outline. And if you guys have any questions, please, you can either, scan my flow code over here, and then it brings you to a landing page and you can schedule a one-on-one with me. It's complimentary. And we also do roundtables with firms. If you have, let's just say you're a firm and you have a bunch of cases that you need, looked at, we do complimentary roundtables, and then we help you determine strategy and whether or not you need coverage counsel at all. And, we can answer any questions. You can also just email me and I will answer the questions. So now let's just talk about depositions. So you're almost always going to want the insurance company representative, right, to testify. They're like the centerpiece of the whole thing. Like when they got this case, what did they do? Did they alert anybody? Did they do a coverage analysis? What did they do? What are their systems? How do they determine what it is? Did you get everything down in the claim file? Is there anything missing? Why isn't this document in there? I mean, these are all things that you want to question this witness about, right? So that witness is really the centerpiece. Now, issues arise when that the person that handled the claim from the beginning is no longer employed, right? And, so then you're just going to have to take the deposition of whatever, adjuster is there that can say what's in the claim file. It's not as effective, obviously. In federal court, you also can ask for the corporate representative. You can get that in state court too. And, in federal court, the corporate representative, a 30B6 witness, that's binding on the carrier. So if they're making statements about what the policies of the company are or what the company would do, that is a binding statement. So that is a very important witness. Sometimes you might want to subpoena non-party the broker or the agent. It just depends on what the issue is. You might want the deposition of the underwriter, right? Again, of course, from the perspective of the carrier, you're going to want the deposition of the insured. Usually, in declaratory judgment actions, usually what happens is they have let's just say the carrier is the plaintiff and the insured is the defendant, and they named the underlying plaintiff as a necessary party, right? Because otherwise, that plaintiff's not bound by the determination. So if they're not a party to the case, they could literally relitigate the entire case over. So they'll name that nominal party, and I have never seen really them independently depose that person because that underlying plaintiff doesn't have any knowledge. One tip I will give you is that what we often do is we try to combine the parties so that the depositions are done all together, so that the defendant's not producing their client twice, right? And the plaintiff doesn't have to produce their client twice. The plaintiff's produced. The plaintiff, may have facts that are relevant to the coverage piece, which most often happens, especially in labor law cases where there's issues on coverage. You have to determine who these plaintiffs are, what their relationship is. So you want to take the depo of that plaintiff, but if you do them all combined, it kind of appeases everybody because now you're having witnesses deposed twice. Okay, so now go ahead, Jocelyn. Talk about a deposition of the insurance company representatives.
Sure. I'm going to just walk you through some typical questions that we would ask. And, as we all know, depositions are very important for building our case for summary judgment. So if you're doing this for the insured or somebody else and you're deposing the insurance company, one thing you really want to focus on is what's their claims handling timeline? When did they first receive notice? Go through the investigation with me in chronological order. Who did you reach out to? When? What responses did you receive? That sort of thing. When did you first identify that there was a coverage concern? And what concern did you identify at that time? When was the decision made to disclaim or deny coverage? How many days elapsed between the time you received notice and the issuance of the disclaimer? And were there any delays in the investigation? If so, what caused those delays? When you're asking about that investigation and also just claims handler's knowledge, you're looking at what documents did you review in making the determination? Who did you speak to? Did you retain any third-party investigators? And if so, what did they find? Did anyone visit the site or do a site inspection? With regard to the disclaimer, you're looking for information on who made the decision to disclaim. Was it this rep? Was it someone else? Did it come from management? Who drafted the disclaimer letter? Was it coverage counsel? Was it someone internal? Were there any changes made to that draft? Who did you send the disclaimer to? A lot of times we'll see where they've disclaimed to the party making the claim, but maybe they forgot to copy the insured. Was it sent to all required parties under Insurance Law 3420? That's really what you're looking for there. What specific policy provisions are you relying on to deny coverage? Those should be in the disclaimer, but they're not always. And did you consider any other basis for a disclaimer that are not in the letter? With respect to policy interpretation and underwriting, again, that's going to go more toward material misrep cases, but are you familiar with the underwriting of the policy? How do you interpret the exclusion at issue? Does the company have guidelines on how to interpret this particular endorsement? If so, what are those guidelines? Where do you find them? Has the company handled similar claims under similar policy language, and how were those claims resolved? Because if they're typically providing coverage to under very similar facts, and then they're denying to your insured, your client, that's obviously a problem. And then you're looking for, more broadly, compliance with best practices. Is the adjuster familiar with the company's claims handling manual? Hopefully you received it in discovery, but maybe they didn't produce it. Or occasionally, maybe there isn't one. Did the rep follow procedures outlined in the manual for that type of claim? And what training did they receive on issuing disclaimers? You'd be surprised. I'm a former insurance rep, and you'd be surprised that there are a lot of gaps in training, even in larger companies. So those are some issues you want to explore during a deposition. With respect to deposing the insured when your client is the insurance carrier, you're looking for, again, notice and cooperation. When did the insured first become aware of the incident? When did they become aware they needed to make a claim? Those are usually simultaneous, but not always. When and how did you notify your insurance carrier? Did you submit it online? Did you call your agent? Did you call a broker? Something else? And did you cooperate with the carrier's investigation? Did the carrier ask you for any follow-up? Did you provide the documents? Were there any delays? If so, why? With respect to policy procurement and alleged misrepresentations, Who is your broker or agent? What did you tell them about your business operations or your property? What representations did you make on the application? And did you read the policy when you received it? Which most people don't. But we want to know, hey, did you read the policy? Were you aware of what was in it? And with respect to the facts of the underlying claim, what is your version of events regarding the underlying occurrence? Who was performing the work in a labor law case? Were they an employee? Were they an independent contractor? Did they work for a subcontractor? Were there any contracts between you and your subcontractor? What were the terms of those contracts? Did they require insurance? Did they require additional insured coverage? And did you obtain any certificates of insurance? And if so, were you listed on this certificate as an additional insured, a certificate holder, what have you? So those are just some of the things that we look for.
Yeah, and again, it's all very dependent on what your issue is, right? We're trying to be like, we're brushing broad strokes here, because if it's a labor law case and that's the issue, and it's one of those, action over exclusions, and we're trying to figure out whether they're an employee or something, or an employee of anybody, it's going to be a different kind of DJ than if you are talking about a late notice or a late disclaimer or material misrep. It's very, very specific to the type of case. So we're really giving you really broad generalizations. So the next thing we're going to talk about, just really we're going to kind of gloss over it because I want to get to something else and talk about experts, but the motion for summary judgment. So the motion for summary judgment is usually the critical pivotal point in the DJ action. And it's either going to be determined in favor of one party, the other party, or a question of fact, right? Just like every motion for summary judgment is. But it's extremely important that you try to get the case decided on a motion for summary judgment, to, determine what everybody's obligations are under the case, but also to really stop the expense. Declaratory judgment actions are so expensive. They're expensive for the policyholder, they're expensive for the carrier, they're expensive for the plaintiffs, it's expensive for everybody. So we don't want to drag these cases out. We just want to get to the point that we need. And oftentimes, right, the issue is there a duty to defend? That's the first question. And that was, is there a duty to indemnify, right? So if the court determines there's a duty to defend, but there's a question of fact on indemnification, then there's a question of fact on indemnification. And oftentimes that is dependent upon what's going on in the underlying case, right? So whenever we do summary judgment motions, we include everything. I have all the transcripts from the underlying action, the transcripts from the DJ. The record is usually voluminous because it's two litigations going on side by side. And, you want to be able to argue why there is an obligation to defend and indemnify. Sometimes what happens is in the underlying action, there's summary judgment that's been granted or denied. Right? And sometimes that is going to impact your DJ action, because if the court finds that there's a question of fact on something, a separate court isn't going to say there's no question of fact if it's the same fact that you need determined. So, and oftentimes these cases are going parallel to one another. You can try to consolidate the cases. I've seen where a third party action is commenced right in the PI case, but it just depends. Sometimes you'll get an objection to that. They'll say it's irrelevant, it's prejudicial, it's going to take too long. Everyone's got a different position on it, right? I think that it's useful having the two cases at least together for discovery and maybe separated for trial if it comes to that point. But the court doesn't always agree with me. So and then some plaintiffs don't want it because they know it's going to delay their case. Right. But that's something that you have to take, again, case by case. And I personally think having all the things together, the two cases together, is really the best, because otherwise they're going at different speeds too. And if you need the decision in the underlying action for your DJ action, but you filed a DJ action because you want a decision, you could end up having, a situation where it's premature. You can't do anything. And sometimes the court will extend your time on the DJ if they know that there are facts in the underlying action, but sometimes they won't. And federal court really typically does not do that. They don't slow up their case for another case, all right? And again, DJ actions, typically what happens is, even if you start them in federal court, let's just say you're a policyholder, if the carrier can remove it to federal court, it gets removed to federal court. We're federal court practitioners and state court practitioners, and federal court is very different from state court in how you have to practice. I'm just going to jump ahead just quickly because we literally only have like 9 minutes left.
I just want to say one thing, Rosa, if that's okay. Just from the defense perspective, because I've been on the other side of this, typically the carrier side will move to sever the actions, at least for the purpose of trial, because it's been held that it's prejudicial for the insurance company to be a party to, a personal injury case, for example. So a lot of times, like I said, like Rosa was saying, it's very useful to have the discovery all in one or going at least simultaneously. But typically on the carrier side, they will move to sever those actions. And in my experience, those motions are granted, although again, you never know what the judge is going to do. So.
And I agree with you. So what I try to do in those cases, or when one's in federal court and one's in state court, you can't do anything about it.
No.
So what I try to do in
living
those
that
cases,
right now.
yeah. What I try to do is I try to combine discovery, but you can't always do it because particularly in the labor law cases, there are so many parties in the other cases, and the coverage cases usually only just a few parties, and so usually it's not practical to do it, and you just have to let them run side by side and see which one gets decided first, right? And from my experience, at the end of the day, the best thing to do is to get all the parties in one room, right? The DJ people and the injury people and the defendants and everybody in the same room to decide to mediate things and move the case forward. Now, just because we only have a couple of minutes, I just want to talk about experts, all right, and DJ actions. So depend again, what kind of case you have? What kind of case is this? So, there are so many coverage cases that go forward with not one expert, right? But then there are others that there are experts required, or that experts get hired and then you have to hire an expert because they hired an expert, right? And that happens quite often. Bad faith cases are the ones where you will see, for example, an expert. Again, I'm not really a fan of that because the expert can't testify on the law. They can't say whether it's bad faith or not. All they can say is whether it's compliance with the standards of care, right? And I think that to me, that's a question for the court personally. So I really don't agree that that's a necessary expert. However, it happens, and some cases do need that kind of expert. But you would need an expert, for example, an underwriting specialist, right? If it's an underwriting issue, you might need an underwriting specialist as your expert, or a damages expert. Let's just say you have a property damage case, which we also handle, and there's an issue about the damages. The other issue is I'm sure you've all heard of the bioeconomy case, right? And this is where the court granted consequential damages. And that case had to do with it was a business interruption policy, and the carrier disclaimed coverage. And because of that, they went out of business. And so the court granted consequential damages to them because of the wrongful disclaimer, right? And that's going to require an expert. You need an economic expert to say what their damages were. So, the other thing is, if you want to talk about Jocelyn, just like selecting how to select the proper expert.
Sure. You're looking for someone with actual industry experience, not just academic credentials. So for example, if you need a coverage expert, a lot of times you're looking for someone who's a retired senior claim executive or some other insurance industry professional. The key thing is you want the expert to have hands-on experience in the specific area that's at issue. So claims handling, underwriting, what have you. You want to make sure they're framing their opinions around industry standards and customs, not purely legal conclusions. The courts are going to limit or even exclude experts who offer legal conclusions. And again, as Rosa mentioned, you see that a lot in bad faith issues. You want to make sure you're vetting your experts' prior testimony and their publications. Look for any inconsistencies, especially if the expert is on the other side of the aisle from you. And consider whether the expert has testified for insureds or carriers or both, to look for any potential bias or positions they could be attacked on.
So, in state court versus federal court, it's very different. when it comes time to strike witnesses, expert witnesses, right? And you have Fry in state court and Daubert in federal court. And, it really is very dependent on what the report says. So for example, in federal court, the reports are exchanged, typically. The reports are exchanged, and you're going to depose the expert. Again, very expensive, very expensive. State court, you don't get to see the report, and the expert doesn't get deposed. So it's two different types of cases. However, there's always going to be these motions in limine to get rid of these experts. And in my experience, and people who have other experiences can comment, but in my experience, the courts will strike certain portions of the testimony and not other portions. So it's usually not an all or none situation. But if the expert is making a legal conclusion, that's not proper. So, one of the things, again, you're going to get into in litigation, and particularly in federal court, you're going to get into these motions. And it becomes, it's time consuming, expensive, and very, very, very involved. So, basically, and I think we have about 3 minutes left. I think that when you're hiring these experts, make sure that when on their CV, that they have the proper expertise, that their opinions are coming from some kind of standard in the industry, whatever that may be, and not just their opinion, which happens quite a bit. It's helpful if they've testified before, right? It's helpful if they've written these reports before. And the other thing, in federal court, you get to see their CVs, and their CVs have, in state court, you get to see the CVs sometimes too. And you get to see all the cases where they testified. So another part of your discovery in a DJ action is to get those cases. And you can demand information on those cases, right? You can look it up on, ECF, NICEF, and what have you, but, sometimes you can't find the cases because they're from other states and you can't get access to them. That's what often happens. But Jocelyn's excellent at researching that and finding cases for us.
Very good at finding things.
Yeah, and so
Thank you.
you're going to get the actual reports in those cases. In some situations, you're going to get the transcripts of their testimony in the cases, and that is extremely useful, as you can imagine, to challenging the expert, whether it's in limine motions or at trial. So I guess, we'll go back to some of the issues. There's only a couple of questions in the queue. But I guess the key takeaways from all of this is, obviously everything up until your motion for summary judgment is critical, and what you get. And sometimes when you get these claim files, they're not orderly, they're not neat, they're not easy to read. When they're looking at and every carrier's got their own systems, right? So I was never a claims adjuster, so I don't know the systems, but I will tell you that, typically you would think there's an email and they would be in chronological order. Well, that doesn't always happen when you get the discovery. Or you would think that, okay, there's a document attached to an email. Well, you don't see that because they're not giving it to you in electronic form. They're giving it to you basically in a PDF, right? So there's a document referred to in there. It's someplace else in the 5,000 pages that they disclose to you, right? So it is very, very difficult to review and read these cases, but it is important. Again, it depends upon your issue. If you have just a late disclaimer issue, past the time that they've determined what the basis to disclaim coverage, you really don't care about the rest of it, right? The only thing, you might want to see is if later on somebody says, oops, look, we missed it, and then all of a sudden you see the disclaimer pop out, right? So, that might be something, but, you really need to tailor this and minimize it because it's just too costly particularly for the policyholder, where we represent them a lot. And these people are paying out of pocket for these things, and they're expensive. So the key to discovery in a DJ is to win on paper, right? And not to have to get to the motions in limine, not to have to get to a trial. I mean, I frankly, there are very few coverage trials because I don't think anybody wants to go to a coverage trial. How can you explain to a jury when it's hard enough for attorneys to figure out what's going on in these cases? So, you just want to win it on the paper. If we want to go back, let me see the questions that are here.
Sure. Do you want me to read them, Rosa?
Yeah, would you? Because the first one I can't really read for some reason.
Sure.
Oh, there we go.
Well, someone commented, Matthew Kaufman commented, real issue is the communications between the broker and the carrier, which may lead to an errors and omissions claim, which can confuse everything. I think that's going back to when we were talking about depositions and claim file discovery, things of that nature. That's absolutely true. On the bright side, if you can bring the broker in and get their E&O in, that's another potential source of coverage, especially if you're on the plaintiff for the policyholder side. Maybe the carrier maybe the carrier did disclaim and their disclaimer was technically timely because the broker sat on the notice of claim for 3, 4 weeks, 6 weeks, whatever, or gave bad advice or what have you. Well, now you might have some way that you can recover damages for your client. So it does complicate things for certain, but it can also be a potential source of coverage.
Want to read the second one?
Yeah, I can read it, or you can. It's up to you. Okay, I'll read, you answer. How's that?
Sounds good.
Okay, from Mark Seidelman. In your opinion, is the injured party a necessary party to a DJ such that it would require dismissal, or is it optional whether or not the carrier includes the injured party in the lawsuit? He has a lawsuit where the injured party was not named in the DJ on summary judgment. They opposed and also asserted that the case should be dismissed on the basis that the injured party was not a party, but was a necessary party, and the court ruled that the injured party need not be a party in the DJ.
Okay, so personally, I'll give you my personal opinion. My personal opinion is that the injured claimant should be a part of the case, because otherwise it's not collateral estoppel to them or res judicata, so technically they could re-argue the whole thing. Now, is that practical? I don't know. It depends. I mean, what's going on. Now, I've had that same thing. I've had sometimes, like, for example, we would move to dismiss for failure to join a necessary party, right? Let's just say we're the insured, all right? And half the time I don't do it because they're just going to name the necessary party and then start all over again. So I contact the other side and I'll say, listen, you really got to name the injured claimant on this or I'm going to move to dismiss. And then they'll, sometimes they'll agree to do it and sometimes not. I mean, I have a case right now where we talked about it and they just didn't want to do it. So that was up to them. As the carrier. I mean, that's really the party that it's going to impact, because now this plaintiff can go back and try and get coverage. So, but I have seen decisions all over the place with it. So I agree. I can understand that you got, a decision that said they're not a necessary party, but in my opinion, they technically are a necessary party, and should be in every case.
Is there any mechanism for attorney's fees to be awarded to one of the parties? For example, if the carrier's disclaimer is found to have been without any merit? Yes and no. It depends. Rosa, please correct me if I'm wrong because you are more experienced than I am, but my understanding is typically if the DJ is brought by the policyholder, they are not going to be able to recover their attorney's fees. If the DJ is brought by the carrier and the policyholder is defending against the DJ and ultimately obtains a judgment in their favor, then their attorney's fees would be recoverable. But again, Rosa would know this better than I would.
Yeah, so the only thing I do want to mention is there are like a line of cases in federal court, which I don't have the name off the top of my head right now, but where, because normally, like what Jocelyn was just saying, if the carrier is the plaintiff in the DJ and the insured is the defendant, then technically they put the insured in a defensive posture and you're allowed to get the legal fees for the DJ action. The legal fees in the underlying action are always given if you win, right? Because they had a duty to defend, right? So those fees should be paid. It's the DJ fees that are the issue, right? So but there are cases, there's at least one or two cases in federal court that say that the carrier placed the insured in a defensive posture in the underlying action because they filed cross claims against them, and they they put them in this position that they placed them in a defensive posture. So even though in that one case the insured was the plaintiff, the court allowed the attorney's fees, right? But it's few and far between. There's just one case, and there's another case that kind of talks about it also, and it was very specific situation. It was like where the carrier had represented both. I'm sorry, it was the insurer for two parties, right? But it disclaimed as to one and not the other. And then they cross-claimed against each other. The one cross-claimed against the other, and the court said in that circumstance, they placed him in a defensive posture. So, okay, I think that was it for that one. And that's it for our questions. If anybody has anything else, let me go back and see if there's anything else we can cover here quickly. So,
Another question, Rosa?
oh, okay, it just popped up. Let me see. Okay.
Danielle, if I have a case where the insurer's counsel failed to seek default judgment against a co-defendant.
Well, I mean, I don't think it's necessarily bad faith. I mean, if they've jeopardized the insured, right, by doing that, then certainly there's going to be a problem. So it just depends on what you'd have to give me a call or contact me so I know more facts out of that, Dan, because I'm not 100% understanding. They failed to take the default. So give me a call so we can, get more details about it.
Chair French, can you address spousal car insurance policies and claims? What is covered? So I know a little bit about this, but Rose, if you want to go first, please do.
No, I mean, the only thing I can say about it is that, typically the insurance policies have, they have now spousal liability coverage.
As of March 2025, right?
Yeah, right. So they didn't used to have that, and a lot of carriers, they offer it, and then you have to, and I think I haven't had this in a while, so someone can correct me if I'm wrong. The carrier offers it, and then you accept it or you don't accept it.
There's a declination form, I believe they have to fill out if they don't want it, and that has to be kept on file.
Right. So, so basically then you have spousal cover. I mean, I recommend everybody get that on their policies, because if you're injured, and your spouse just was negligent in the way they drove, then, but there's an exclusion, and maybe this is what the confusion is. In the old days, right, there was an exclusion in the policy that would exclude coverage for spousal claims.
Yeah, so if your husband was driving and crashed and you were injured as a passenger, you would not be entitled to a BI claim under your auto policy.
Right. And then what happened was this spousal liability coverage came down. It was a statutory change, and the spousal liability coverage came down. And sometimes the carriers would still have that exclusion in it, but then would have the spousal liability, which conflict with one another. So in those cases, it's always going to be the spousal liability is going to apply, the spousal liability coverage is going to apply. So that you really have to look at the policy and whether or not they declined it. They declined that coverage.
Okay. From a former coworker of mine, Chris Sasadiak, and I'm sorry, I know I'm mispronouncing your last name. Hello. What are some examples of quote unquote color commentary that would not be protected by privilege?
Okay, so the adjuster commenting about how the insured is an idiot or
a liar.
Right. Or I saw a defense deposition, which I'm not going to repeat what was said in it. But they basically commented on the clothing that this witness was wearing. It was a party to the case, and it might have been funny to him, but it might not be funny to somebody else. So it's that kind of thing. When they're making comments, personal comments about the parties to the case.
Like ad hominem attacks are typically not going to be protected.
Right.
And could be used against the carrier. So
yes. Yeah.
From Mitchell Wynn, how do you protect yourself from a late notice defense if you request that a party defendant place their liability carrier on notice and they don't do it and they won't disclose who their carrier is until later when you're in suit?
All right. Well, I mean, Mitchell, I'm sure that you've encountered this. I mean, the key is finding out who the carrier is, right? And I understand when it's not an auto case, see, the injured claimant, right, has a right to place the carrier on notice. Under insurance law 3420, and their notice is deemed notice on behalf of the insured. That's really the way I read it. So oftentimes, depends on the case. In an auto case, that's easy because there's a police report with a code on it, right? In a
The
homeowner
DMV
case,
records.
I'm
If there
sorry.
isn't a police, if there isn't a police report, sometimes you can get that information from the DMV records.
Right. And then another way is, for example, if you know who, like if you can find somebody's vehicle, let's just say, right, and you know who the carrier is in the vehicle, it might be the same carrier on like their homeowners, right? So you can, if you can find out what cars they own, then or vehicles, then you might be able to go to that broker and say, we're placing this, on notice of a homeowner claim or a business claim. With the like in the labor law cases, I find that often it's easier, a little bit easier, because there are certificates of insurance flying around everywhere, and you should be able to find something from those certificates of insurance. But that is really the only way. And again, if you're an aggrieved party, right, to the case, you have a right to find out who the carrier is and to, and just demand it right away. Once you file that action, you serve, they're supposed to serve their discovery responses and their insurance disclosures within 90 days, right? Which I know it doesn't happen. I've seen some firms do. Some firms are very religious about it, but some firms do not. And you just got to push. That's the only way.
Attendance code number 2 is WAR017. That's WAR017.
Let's see.
From Lilas Borsa, and again, I'm sorry if I'm butchering these names. As a plaintiff's attorney, are there red flags to look out for that a DJ might be in the offing? Disclaimers. Those are probably the biggest red flag that you can get, that a DJ may be coming. And some carriers are more proactive than others. Some will issue their DJ, and as long as they feel that it's pretty strong, they're going to file a DJ, or excuse me, they're going to issue their disclaimer and they're going to file a DJ pretty much right away. Other carriers don't typically want to incur the expense if they don't have to, so they'll just sit on their disclaimer, wait and see if it gets challenged, wait and see if someone files a DJ against them. But yeah, typically the disclaimer is probably the biggest red flag. If you find out that if it's a personal injury case, if there are EUOs being demanded, that can be a sign. Those are probably, I'm trying to think from my experience as a claims rep, but those would be probably the biggest tells of my actions to outside parties. If I'm demanding EUOs, if I'm setting reservations of rights, saying the claim is still under investigation. But those would be the biggest red flags, I would say. Rosa, do you have any others that you'd like to add?
No, and I just to comment on that, piggyback on it, oftentimes we have, plaintiffs firms that we work with, and what they'll do is when they get their disclaimers or these reservations of rights, they'll look at them. If they can figure it out, great. But otherwise, they'll call us or send me an email and say, look, can you take a look at this for us? We just want to make sure this isn't going to impact our recovery, or is there a strategy that we should be taking to try to figure this out? Because unfortunately, in New York, the injured plaintiff does not have a right to commence, in most cases, except for a small one little exception for late notice, does not have the right to commence a DJ action until they have a judgment that's unsatisfied for 30 days. But there are other ways around that. And there are other ways to get involved with the coverage piece without having to file the DJ, which we often get involved in. And then, sometimes you do have to wait for the carrier to file it or the insured to file it.
One thing we'll do prior to commencing a DJ, if someone receives a disclaimer and then they retain us, we'll issue a pushback letter saying, hey, here's why we think your disclaimer is deficient. We're requesting you reconsider and provide defense or indemnification or both, typically both. So that's something that you can do prior to going the DJ route.
Yeah.
Jamie Farrell. If a DJ action has been filed by the carrier as a plaintiff and a physician is the defendant for the physician's conduct and the former patients/victims were included in the DJ action, what contribution do the former patients make in discovery if the issue is whether there is a duty to defend by the carrier, if any? It's pretty fact specific. Go ahead, Rosa, I'll let you
Yeah,
start that
sure.
one.
I mean, it just depends. I mean, that is a very, very specific fact, and there might not be anything that they can contribute to it at all. But again, the reason why they're in the case is because they'll be bound by whatever the finding is. So if they don't want to participate, they don't have to participate, but they can make an argument, even if it's on your behalf. I mean, I've done that. I've done that saying, no, the disclaimer's wrong because X, Y, Z, or ambiguous or whatever the argument is, even though it's really not your fight as a plaintiff, but because you're a necessary party to the case and you're added to the case, you're entitled to participate and to raise any defenses that you see that maybe somebody else doesn't see.
It's also going to depend on what the nature of the DJ action is. If it's a material misrep, the patients probably don't have documentation, but maybe they do. Maybe the disclaimer was saying, oh, you said it was, again, I'm just kind of creating an example, but when you took out this policy, you said it was an acupuncture practice, but I found out you're doing chiro and that somehow violates the terms of the policy we issued. Maybe your patients could say, no, we were undergoing acupuncture. So it's really going to depend on what the basis for the disclaimer and what the basis for the DJ is. But it is possible that the clients might be able to provide some documentation or some testimony that helps support a claim for coverage under the policy. From Joseph Furlong, in today's Newsday is a letter from a single male who is being billed for spousal coverage.
Okay.
That sounds like some sort of administrative error that the carrier definitely should have rectified, and I hope he's able to get his extra premium refunded on that.
I think sometimes what happens is it's automatically put onto the policy. And but again, this is where you have to read your policy. And when you get those policies, as individuals that, we're not just the lawyers handling it, you have to read it. And I know I oftentimes, even myself, I get the policy and I'm like, oh, I throw it on my desk, I don't have time for this. But it's important to review your policy and see what you're being charged for. Okay, let's see.
Further clarification from Danielle.
Okay.
So I think the carrier's counsel in the underlying action failed to seek a default judgment because the carrier knew that the particular co-defendant was also one of its insured. I'm pretty sure, I believe the carrier counsel did not go ahead and seek a default judgment because they did not want to jeopardize the insurer.
So I guess, Mike, the question, and again, I hate to say I need more information, but I do, because what's the prejudice to your client? So that they didn't take the default. So I'm just not sure if you're saying that's also a liable party, I guess you're saying, right, Jocelyn, you have any input here? I mean, that they're also a liable party and then they take a default, but I'd have to know more about the case and how they, right, the insurer's trying to disclaim to your client, but then what's the prejudice to your client that they didn't take a default on the co-defendant?
Yeah.
So that's the problem. That's why I just definitely reach out to me, Dan, and call me because I'll have to get a lot more facts from you. And that's kind of, it's kind of what we do. So we oftentimes will just get calls or emails from clients and, we will take a look at it and we'll say, okay, yes, this is probably something you should pursue, or no, this is probably something you shouldn't pursue, and that way people have the option because, as I said, it could just be a simple pushback letter to the carrier. It could be, and oftentimes, sometimes the pushback letter will work, right? It'll push the carrier to settle the claim or to contribute to the claim. And, knowing that they might be in a bad faith situation if they fail to take that default. Oh, so this is like a car accident case or something. The co-defendant is jointly and severally liable. Yeah, so it could be, that could be something. I mean, that could certainly be something. At the end of the day, they failed to do that. That might, but again, I'd have to really think the whole thing through because if they don't owe you coverage to begin with, then you're not prejudiced by that. So I think that's going to determine, what course of action you need to take, whether or not it was prejudicial what they did by not taking the default.
I often represent plaintiffs against defendants whose commercial liability carriers have disclaimed coverage. Would it be advisable/appropriate for me to refer an adverse party to a firm like yours if they may be entitled to a defense and therefore may have a viable coverage action?
Why not?
Yeah, absolutely.
I mean, if the insured is sitting there without coverage and it looks like, and this is what happens, Elizabeth, the plaintiff's firms will send me the disclaimer, and then I'll look at it and I'll say, yeah, this is solid, or there's probably an issue here, a potential issue. And then, obviously we can do that pushback letter or urge, you can probably urge that other attorney, the attorney for the defendant or the defendant, hey, look, you guys should probably get insurance coverage counsel because it looks like there's a problem with with the disclaimer. And that happens. I mean, I can't represent both. There would be a conflict for me to represent both people, but I'm just saying it would be, certainly that is something that occurs. They get referred to us to see if we can help them out.
Yeah, because the plaintiff wants there to be coverage and the defendant also wants there to be coverage, so they're not on the hook on their own. So yeah, we do sometimes, we've had that arise in the past, I believe, where now a defendant in an underlying action was referred to us to try to challenge the disclaimer because it benefits everybody involved in that underlying action.
So let me see if I'm going to go back. Where the extra premium is paid for spousal coverage on the primary policy, does the umbrella also cover that loss? I don't
depend on the terms of the umbrella.
Yeah,
right?
I don't think it's automatic. I think that you have to opt for it. And look, that's something that we could talk about for a few minutes on these cases. That I actually have something right now, a case right now where the primary policy covered the entity and the individual, and the excess policy didn't. Right? And so again, that's going to be an issue of, well, wait a second, how did this happen? What's the situation with the underwriting? So it's just as important to look at the umbrella policies and the excess policies as it is to look at the primary policies when you're a plaintiff. And we have a case here. I don't know what the case is, but we'll look at it.
For Danielle, see Hartford v. Michigan Mutual. And there's a case site in there as well for you.
So, it's very important for everybody to have their policies, your clients, and when you're a plaintiff, to ask for these policies, not just the primary. You want to see the umbrella policy or the excess policy, whichever it is, and review that. And the excess carrier has an obligation to disclaim just like the primary carrier does. It's just that they have to be placed on notice. And we encounter this quite often where we'll see the primary carrier is placed on notice, but the excess carrier isn't. And now all of a sudden it's the eve of trial and the excess carrier pops up, comes out of the woodwork, and now it's too late. The excess carrier is going to disclaim coverage. So you want to make sure that you have disclosures of all of that type of stuff in your actions, whether you're a defendant and you're seeking subrogation or, contractual indemnification or whatever it is, or you're a plaintiff trying to find out what coverage there is on your case. I mean, we were having a discussion the other day is that the days of just looking at, like, for example, in the construction cases, of just looking at a certificate of insurance to determine whether or not there's coverage, those days are over. I mean, every policy has its very specific terms now with the E&S market now. There are the carriers that are, the New York regulated carriers, and there's the other ones. There are so many provisions in those policies that never existed. And so you really have to read, the policies and get them as a party to a case. I'd ask you're entitled to get the actual policies themselves, and you just have to review them and see if there's an issue. If there's no disclaimer, then there's no issue. But if there's a disclaimer or reservation of rights, even there's an issue. So let's see this case. Hartford versus Michigan. It's an oldie but a goodie, I guess.
Yeah.
1984.
Talks about the duty of good faith and fair dealing owed by the primary insurer to the excess insurer in connection with handling the underlying claim.
Yes, and allows the excess insurer to sue the primary insurer if they acted poorly. And that is something that defendants need to be very, very careful with now. because I've seen more and more where the carriers are suing the defense lawyers when they make a mistake. And that, in the old days, that didn't happen. But I've seen it. And so you really do need to be on top of figuring out who's got what coverage and where you're getting it from and who you can cross claim against and how many layers your client has and all that good stuff.
Mhm.
Thank you, everybody, for spending your afternoon with us.
Yeah, thank you for coming. Thank you for the great questions. Hope to see you soon or talk to some of you soon.
Thank you, Rosa and Jocelyn, for providing such a great program on declaratory judgment actions. I look forward to having you back for more episodes. And for my listeners out there, please let me know what you thought. And if you'd like to hear some more content from Rosa, Jocelyn, and maybe some of my other attorneys in the firm. Thanks, and have a great day.